Nnamdi Kanu, do Igbo leaders really have to beg Buhari? Welcome to the news and please subscribe to our channel. On the 19th November 2021, the news of some highly respected Igbo leaders who visited President Muhammadu Buhari at Aso Rock greeted the major space, setting the pace for dissenting opinions by Nigerians. The social media agog when the details of a meeting was finally revealed by the special advisor to the president on media and publicity, Femi Adesina, who said the Igbo leaders under the aegis of highly respected Igbo greats appealed to the president to ensure the release of the proscribed indigenous people of Biafra leader Nnamdi Kanu. The group, led by First Republic parliamentarian and former Minister of Aviation, 93-year-old Mbazulike Amechi, begged Buhari to release Nnamdi Kanu, his stern critic. As expected, Buhari, while responding to the Igbo leader, stated that though the demand was heavy, he would consider it. The phrase "consider it" suggests the freedom of the IPOD leader will be subjected to unconditional release, and by inference, Mr. President, having the veto power, can decide to pardon Nnamdi Kanu without necessarily waiting for the judiciary to give its verdict. But the question is, do Igbo leaders really need to beg Buhari to secure Nnamdi Kanu's release? It would take a deep and reflective thinker to dissect the question. Is Nnamdi Kanu protected by the law? The IPOB leader, as far as the law is concerned, is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. The Nigeria Terrorism Act of 2013 gives the court the powers to conduct such trial terrorism under more restrictive circumstances, as is the case in certain parts of the country. These laws are in line with global standards, including those of the USA Patriot Act of 2001, Section 802 to 811. According to the Practice, Direction and Protocol of Terrorism Prevention Amendment Act 2013, Section 34, Subsection 3, the courts may also decide in the public interest and national security that A or all any of the proceedings pending before the courts shall not be published in any manner, and that such proceedings shall be adjourned, and the accused person detained pending when the Attorney General is able to guarantee the protection of persons and safety of the witnesses and other persons involved in the matter. Similarly, the Administration of Criminal Justice Act of 2015, Section 233, Subsection 1, a trial for the offense referred to Subsection 4 of this section may not, where the court so determines, be held in an open court. This is a position of a law which should be strictly followed by the courts if Nnamdi Kanu must be given a fair hearing. But it is sad when rule of law becomes the rule of engagement between the executive and judiciary to subject a suspect to heinous treatment, where mental stress and emotional distress becomes the order of the day for the alleged criminal. Begging is not an option. Based on popular opinion, the Igbo leaders perhaps might have thought the treatment of Nnamdi Kanu in detention was alleged is dehumanizing and unlawful. But begging Buhari for quick release is not an option the Igbo should be considering now. The president should not be compelled to release Nnamdi Kanu if he can free repentant terrorists, Boko Haram members, without any strict condition attached. Shouldn't he, Buhari, voluntarily release Nnamdi Kanu if his soul wishes and not until he is being begged? For some, begging Buhari goes against the nature of an average Igbo man who is presumed to be proud and fearless, no matter who he is dealing with. Hence, begging someone they see as enemy to release their kinsman is strange to the Igbo culture. This customary culture, however, might have been violated when the Igbo leaders visited Buhari to appeal for the release of Nnamdi Kanu, which they later could have declined if consulted before the Igbo leaders took the decision. The ultimate solution to the release of Nnamdi Kanu right now is the rule of law, which is questionable to an extent in Nigeria as a result of the various actors enacting this law. In a Senate crime, a suspect is presumed guilty, otherwise proven by law through fair trial. But this seems not to be tenable in Nigeria, where it can be difficult to differentiate between who a criminal is from who is not. Nnamdi Kanu deserves a fair hearing as against the political begging where no solution lies. To be sincere, all these acts of terrorism that is being stated here, I do not see it as being very necessary, because if you look at it, everything is clear. In a democratic system of government, one has the right for peaceful protest. You can come out and say this government is not doing their work well as a citizen of Nigeria. You can come out when you're pressed. You can come out when things are not going right in the state, and it is your civil right. Now, tagging this particular man now as a terrorist is what I do not understand. He has the right to protest. When you are being oppressed, you have the right. Except they want to tell me that all the laws now, all the civil or fundamental human rights that exist only on ink and paper. Except that. But aside from that, this man is not a terrorist. Why would the Boko Haram be pardoned when this said Boko Haram they have killed? They are bloodsuckers, vampires, monsters.